Tonight, we begin with a development that immigration attorneys, civil rights advocates, and legal experts had feared, dismissed, and desperately prepared for. A decision that unfolded not over months of debate, but in a single afternoon. A single afternoon that changed the lives of millions. A single afternoon that rewrote decades of immigration precedent. A single afternoon that left green card holders across America scrambling for answers. What the administration did today crossed a line that constitutional scholars had hoped would hold. And when that line broke, immigration advocates did not hesitate. They responded with urgency, precision, and an unprecedented mobilization of legal resources. If you hold a green card, if someone you love holds a green card, if you are in the process of applying for permanent residency, you need to watch every second of what comes next. For months now, there had been signals, not official announcements, not formal policy drafts, just signals that the White House was preparing something unprecedented. The administration has been aggressive on immigration, yes, but they have been predictable in their aggression. Their moves have followed a certain rhythm, a pattern, almost a choreography. But what set off alarm bells in Washington this week was that the pattern went silent. Immigration attorneys who monitor policy changes know the indicators: the sudden cancellation of stakeholder meetings, the quiet reassignment of key DHS personnel, the unusual activity at USCIS processing centers, the sudden freeze on certain application categories. All of that went quiet, and whenever this administration goes quiet on immigration, it means something is about to get loud. For weeks, advocacy groups had been tracking unusual movements within the Department of Homeland Security. Internal communications, obtained by several news organizations, suggested that a major policy shift was imminent. Legal experts warned that the administration was looking for ways to expand deportation authority beyond undocumented immigrants, potentially targeting those with legal status who had previously been considered protected. Green card holders, lawful permanent residents who have built lives, raised families, paid taxes, and contributed to communities across America, suddenly found themselves in an unfamiliar position. They found themselves afraid. They found themselves uncertain. They found themselves wondering if the green card in their wallet still meant what it had always meant. And today, those fears were confirmed. Early this afternoon, White House officials confirmed what they described as a comprehensive enforcement enhancement directive, including provisions that had not been activated in over 40 years. These are the kinds of executive actions that administrations only deploy when they are signaling something very specific: a fundamental shift in enforcement priorities, a complete reimagining of who qualifies for protection, or a direct challenge to existing legal frameworks. Immigration attorneys didn't know which category this fell into, or whether it fell into all three at once. But what they did know was that the administration was changing its posture on legal immigration. And when any administration shifts its posture on permanent residency without explanation, even by the smallest measure, every green card holder in America should pay attention. Here's what the order actually contains. The new directive, signed this morning, expands the categories of offenses that can trigger deportation proceedings for green card holders. Previously, only serious felonies, what immigration law calls aggravated felonies, could put permanent residents at risk. Under this new order, the threshold has been dramatically lowered. Minor drug offenses, certain misdemeanors, even some traffic violations, if they're classified as criminal matters, could now trigger removal proceedings. But it gets worse. The order also includes a provision for retrospective enforcement, meaning offenses that occurred years ago, even decades ago. Offenses that were already adjudicated and closed can now be reopened and used as grounds for deportation. Green card holders who thought their past was behind them are waking up tonight to a terrifying new reality. That DUI from 15 years ago, it could now cost you your green card. That misdemeanor plea deal your attorney assured you wouldn't affect your status? It might. That mistake you made in your 20s, paid for and moved on from? The government hasn't forgotten. And now, they're coming back for it. The warning issued by the American Immigration Lawyers Association tonight was not normal. It was not routine. It was not symbolic. It was urgent. Attorney after attorney, in conference call after conference call, described the administration's move as unprecedented, constitutionally questionable, and perhaps, most importantly, immediately enforceable. That last part is what matters most. This isn't a proposal. This isn't a draft. This isn't something working its way through Congress. This is signed. This is active. This is happening right now. But executive overreach only works if the target hesitates. Immigration advocates did not. In fact, their response today was among the fastest and most coordinated we've seen in modern immigration law. Here's what we know. Within 3 hours of the order being signed, the ACLU filed an emergency motion in federal court challenging the order's constitutionality. These weren't standard legal filings. These were emergency injunction requests, the legal tools that advocacy groups only deploy when they are preparing to fight for immediate relief. Simultaneously, immigrant rights organizations across the country activated what they call rapid response networks. Volunteer attorneys, legal aid societies, and community organizations prepared to provide immediate assistance to affected families. Hotlines that normally receive dozens of calls per day were flooded with thousands. Legal clinics that typically book appointments weeks in advance opened their doors for emergency walk-ins. And on social media, immigration attorneys began posting urgent warnings, telling green card holders exactly what steps they need to take right now to protect themselves. The response was swift. The response was coordinated. The response was necessary. Because the administration made something very clear today. They are not interested in gradual policy shifts. They are interested in shock and awe. They want green card holders afraid. They want immigrant communities destabilized. They want people to make mistakes out of panic. And the only antidote to that strategy is information, preparation, and immediate action. Tonight, legal experts confirmed that the order targets several specific categories of green card holders, including those with minor criminal histories that had previously been considered non-deportable offenses. The administration moved before Congress could respond, before courts could intervene, before affected families could prepare. They targeted green card holders with old misdemeanors. They targeted those with dismissed charges that still appear on background checks. They targeted individuals whose offenses occurred before they even became permanent residents. In other words, the administration targeted the most vulnerable legal immigrants, those who thought they had done everything right. The provision that would have protected them from retroactive enforcement eliminated. The requirement for prosecutorial discretion stripped away. The recognition that permanent residents have constitutional rights ignored. This is what made the ACLU's emergency filing so urgent. The administration's order wasn't just symbolic, it was immediately actionable. It represented the kind of executive overreach that could destroy families if left unchecked, and immigration advocates, understanding that fully, responded with force. Not recklessly, not impulsively, but strategically. They didn't file broad, unfocused challenges that could be easily dismissed. They didn't make political statements that would be ignored by courts. They hit the constitutional weak points. They hit the due process violations. They targeted the specific provisions most likely to be struck down. Legal experts are now analyzing every word of the order, looking for vulnerabilities, looking for inconsistencies, looking for the legal leverage that could bring this directive to a halt. But here's what green card holders need to understand. Even if courts eventually block this order, the damage may already be done. Immigration and Customs Enforcement has already been briefed on the new enforcement priorities. Deportation officers are already receiving updated guidance. Cases that were previously closed are already being reopened. The legal challenges will take weeks, perhaps months. But enforcement begins tonight. That's why this moment requires immediate action. Not tomorrow, not next week, now. And here's where the story becomes even more alarming. Legal analysts now believe that the administration's latest move was designed to test the limits of executive authority after a series of court victories emboldened their enforcement agenda. The administration wanted to see whether immigrant communities would collapse into fear. But instead, the opposite happened. Advocacy groups didn't retreat. They mobilized with a speed and coordination that was so immediate, so comprehensive, that even administration officials noticed. You don't get Washington's attention easily. But today, immigration advocates did. Former DHS officials speaking with reporters under anonymity described the administration's strategy as maximum pressure, a way to force as many deportations as possible before courts can intervene. But advocates proved today that they remain both vigilant and prepared. Their legal filings were not only swift, they were targeted so precisely that they addressed each constitutional violation individually. That precision matters because it shows something important. It shows that the immigrant rights community has been preparing for this moment. It shows that green card holders are not alone. They are not defenseless. They have advocates fighting for them right now at this very moment. But those advocates can only do so much. The rest depends on you. If you are a green card holder with any criminal history, no matter how minor, no matter how long ago, you need to take action immediately. You need to gather your documents. You need to consult with an immigration attorney. You need to understand your rights before ICE comes knocking on your door. Because tonight, the rules changed. And if you're not prepared, you could lose everything. As reports continued coming in throughout the evening, we learned more about the scale of the administration's enforcement expansion. USCIS confirmed they are reviewing millions of previously closed cases for potential reopening. ICE field offices nationwide received updated enforcement guidance within hours of the signing. Local law enforcement agencies in sanctuary cities reported receiving federal pressure to cooperate with immigration enforcement. This wasn't just a policy memo. This wasn't just an administrative adjustment. This was a fundamental transformation of immigration enforcement. This was a declaration of war on legal immigrants. And legal immigration is the one thing this administration has struggled to attack directly since taking office. For every restriction they have attempted, courts have pushed back. For every enforcement expansion they have tried, advocates have found vulnerabilities. But this order is different. This order was crafted specifically to survive legal challenges. Every word was chosen carefully. Every provision was designed to exploit existing loopholes in immigration law. The administration learned from their previous defeats. And tonight, they're putting those lessons into action. Remember, the administration thought green card holders would be too afraid to fight back. They thought immigrant communities would fragment under pressure. They thought advocacy groups would be overwhelmed and unable to respond. But tonight, the exact opposite is happening. Immigration attorneys are working through the night preparing emergency filings. Community organizations are holding Know Your Rights workshops in cities across America. Families are gathering their documents, consulting with lawyers, and preparing for whatever comes next. This is not a community in collapse. This is a community in resistance. And that resistance has already begun producing results. Within hours of the order being signed, a federal judge in California agreed to hear an emergency motion challenging its constitutionality. That hearing is scheduled for tomorrow morning. If advocates succeed, the order could be temporarily blocked within 24 hours. If they fail, enforcement will accelerate immediately. The next day will determine the fate of millions. What makes this moment so critical and so dangerous is that the administration's latest move happened at a time when immigrant communities are already under unprecedented pressure. Hardliners want mass deportations, regardless of legal status. Moderates want targeted enforcement that doesn't affect legal residents. Business groups want to protect the immigrant workers their industries depend on. Civil rights organizations want to protect constitutional principles. The administration is balancing these demands while facing mounting legal challenges on multiple fronts. And when administrations in that position make sudden, aggressive moves, they're not doing it from strength. They're doing it from pressure. They're doing it from desperation. They're doing it because they know the window for action is closing. Courts are increasingly skeptical of executive overreach. Public opinion is shifting on immigration. Congressional support for extreme enforcement is wavering. This order may be the administration's last chance to achieve their most aggressive immigration goals. And that's exactly why they're moving so fast. They know time is not on their side. They know that every day of delay is a day for opposition to organize. They know that if they don't act now, they may never get another chance. And so they're acting aggressively, immediately, without regard for the families they're destroying. The statement issued by Democratic congressional leaders, now circulating across news networks, was designed to signal that Congress is not willing to allow the destruction of legal immigration without a fight. Senior lawmakers said plainly that the administration's order was inconsistent with American values and constitutional principles. That is diplomatic language for, "This is illegal and we will fight it with everything we have." You don't usually hear that tone from congressional leadership unless something serious is at stake. And tonight, something very serious is at stake. The fundamental promise of the green card, that legal permanent residents have a secure place in American society, is under direct attack. If this order stands, that promise means nothing. If this order stands, no green card holder in America is safe. If this order stands, legal immigration as we know it is over. That's why the response from Congress matters. That's why the legal challenges matter. That's why your response matters. Meanwhile, the head of the largest immigrant rights organization in America addressed supporters in an urgent video message tonight. She said, "This order is not just an attack on immigrants. It's an attack on the rule of law itself." She said, "We have been preparing for this moment, and we are ready to fight." And she said, "To every green card holder watching tonight, you are not alone, and you are not without rights." These are not rhetorical flourishes. These are statements from an organization that understands just how high the stakes have become. They understand that millions of families are afraid tonight. They understand that the next few days will determine everything. And they understand that silence is not an option. Here's what makes the situation even more concerning. The administration's latest order wasn't isolated. Along with the deportation expansion, ICE announced increased workplace enforcement operations targeting legal workers. USCIS implemented new extreme vetting procedures for green card renewals. The State Department tightened restrictions on travel for permanent residents from certain countries. All of this happened within the same 72-hour period. When the administration moves multiple pieces at once, it means something larger is underway. This isn't random. This isn't coincidental. This is a coordinated strategy to fundamentally transform legal immigration in America. And if green card holders don't respond with equal coordination, equal urgency, and equal determination, this strategy will succeed. The administration is betting on fear. They're betting on confusion. They're betting that immigrant communities will be too overwhelmed to fight back. Don't let them win that bet. Legal analysts are now considering several possibilities. One is that the administration is preparing for a larger enforcement operation targeting legal residents in specific geographic areas. Another is that the administration is attempting to pressure green card holders into leaving voluntarily through fear and uncertainty. A third possibility, the one worrying advocates the most, is that the administration is attempting to redefine permanent residency itself, transforming it from a secure status into a conditional one. But today, immigration advocates took that uncertainty and transformed it into action. They didn't wait for clarification. They didn't wait for implementation. They didn't wait for the first families to be destroyed. They filed immediately. They organized immediately. They fought back immediately. And that's exactly what you need to do. What we're watching now is a test of American values. The administration wants to see how far they can push before consequences arrive. Advocates want to show that constitutional principles still matter. Courts want to preserve the rule of law, and green card holders want to protect the lives they've built. The outcome of this test will shape immigration policy for decades, and every action taken in the next few days will matter. Tonight, we've heard from legal experts who are now monitoring developments across the country. They say the first enforcement actions under the new order could begin within days. They say green card holders with any criminal history should consult an attorney immediately. And they say the administration's decision to move so quickly is likely part of a broader strategy intended to create maximum disruption before courts can intervene. But advocates are not backing down. In fact, advocates are escalating. Their response today, swift, coordinated, and legally precise, sent a message to the administration that this fight is just beginning. And it sent a message to green card holders that they have people fighting for them. You are not invisible. You are not forgotten. You are not alone, but you must act now. As the night goes on, we expect more details to emerge about what exactly the administration hoped to achieve with this order. But what we do know is that the legal response was immediate. It provided hope to terrified families. It established the framework for constitutional challenges, and it proved that immigrant communities will not go quietly. What happens next will depend on what the administration does in the next 72 hours. If they pause enforcement pending legal review, this moment will be remembered as a temporary crisis. If they accelerate enforcement despite court challenges, advocates have already shown they are prepared to fight every case, in every court, for as long as it takes. And tonight, for the first time in years, the administration appears to be facing real resistance. Washington is watching, the courts are watching, and millions of green card holders are watching, waiting, and preparing. Because tonight, everyone learned something they should have known all along. Green card holders will not be erased quietly. Immigrant communities will not surrender their rights without a fight. And the Constitution still means something in America. The story is far from over. But tonight, one thing is clear. The fight has begun. The stakes could not be higher, and your action, right now, tonight, could make all the difference. Share this video with every green card holder you know. Consult an immigration attorney immediately. And whatever you do, do not wait, because tomorrow may be too late.